My
This
name is
conference
Jessica
will now be
Phoenix,
recorded.
and I would like to welcome you to today's webinar, Understanding the Ins and Outs of Medical Leave Absences. Before we begin, I'd like to review a few points of protocol so that you'll get the most out of your webinar experience. Remember, you are listening to the conference via a conference service. If you are disconnected, repeat the steps that were given to you in the registration email. In order to reduce background noise, please mute your microphones during the presentation. If you have any questions, please type them in the chat box. The chat icon is located at the top right-hand side of your screen, and our presenter will address questions as they become available or at the conclusion of the presentation. Please note that today's program is being recorded. Now it is my pleasure to introduce our presenter, Mrs. Jamie Hasty. Jamie Hasty is a Vice President with SESCO Management Consultants in Richmond, Virginia. Jamie graduated from East Tennessee State University with a BBA in Human Resources Management. Jamie is a generalist consultant in all areas of human resource management with specialties in affirmative action, policy development, wage and hour accounting, employment regulation compliance, training and development, compensation and performance management systems, employee satisfaction assessments, executive screening and placement, and general human resources consulting. She regularly conducts management training for clients and serves as a guest speaker for state and national associations. Jamie is a certified trainer for Vital Learning Corporation, John Maxwell, and SESCO Leadership Institute. Ladies and gentlemen, please welcome Ms. Jamie Hasty.
Thank you, Jessica, and thanks everybody for joining us today. It's a pleasure to be back with you all. Today we're going to talk a little bit about the ins and outs of different types of medical leave of absences. It's something that we deal with regularly at SESCO from our clients having questions about FMLA, Americans with Disabilities Act, and the voluminous paperwork that goes along with it. So again, we're going to kind of focus on the two main federal ones. I probably will reference state medical leaves as well, because as a reminder, there are a variety of states that require family leave, paid sick leave, those sorts of things. So I want to focus on, again, FMLA and ADAAA. And then as a reminder, both ASA and ACIL have telephone and email consulting access to SESCO as a member benefit. So if you ever run into situations where you need forms or you need a templated letter or you have questions about what to do with somebody when a medical situation arises, please feel free to reach out, utilize that membership benefit. And you can speak with any of the senior consulting staff and our employment attorneys on staff. So let's roll into Family Medical Leave Act. FMLA is one of those things that still seems to be a little bit elusive for some, but there are certain requirements for employers if they have 50 or more full-time employees, 50 or more employees. It's headcount, not full-time or part-time status, during 20 or more calendar work weeks in the current and or preceding year. Now, the interesting thing about that is the work weeks need not be consecutive. So particularly for our ASA members, when we have hiring booms based on project work and that sort of thing, it's very easy to cross that 50 threshold without really realizing it, and we may be subject to FMLA. Also, if we have 50 or more employees within a 75-mile radius, if we have multiple sites, that's going to count as well. We have obviously engaged in commerce in any industry or activity affecting commerce.
Jamie, yeah. Sorry to interrupt you. On your screen, we're seeing all of the slides instead of just the one slide you're presenting on. Can you switch to the slideshow mode?
Well, that's interesting because I am in slideshow mode. Okay, let's go back. All right, can you see the main slide?
We cannot. We can still see all the slides.
Okay, let's see, current slide. It should be titled FMLA.
I can see where you've highlighted the slide, but it still was all of them. Now nothing is
Yeah,
showing.
yeah, I'm not really sure what's going on, Jessica, because I'm in, I'm in slideshow mode.
Okay.
Let's see. The joys of technology, everybody. The joys of technology.
We have someone that's saying hit setup slideshow.
Okay. Not really sure what that is. Is that working now?
No.
Okay. Well,
Jamie, if you want to send me the slides, and you can keep
yeah,
going and we'll pull it up and we'll do it from my screen.
let's do it that way. I like that idea. Okay. All right, let me stop sharing so you don't see all of these screens. Okay, let's do that very quickly. So thank you all so much for your patience. We will get this all figured out. But when we talk about FMLA, again, it's going to be based on your employee head count. The other thing is that not everybody is going to be eligible for FMLA. That's a common misconception that we run across a lot of times, is that employees, especially newly hired employees, whether they need to go out for birth or surgery or something of that nature, they may not have been employed long enough to be eligible under federal FMLA. That doesn't necessarily mean that they wouldn't qualify if there was another state paid job protected leave. But in terms of the federal piece, they're probably not going to be covered. So they first and foremost have to work for an employer who has 50 or more employees, and they have to be employed under FMLA for at least 12 months. And within that 12-month period, worked no less than 1,250 hours. Okay. Now, that 1,250 hours piece is not going to include vacation, personal, sick time, holidays, those sorts of things. It's actual hours worked. So interestingly enough, there's also a very vague, I shouldn't say vague, there is a provision that many people are not aware of that deals with what we call a break in service. So let's just assume that Jessica worked for ABC company and worked there for 2 or 3 years and then left for 3 years, but then was rehired. Okay. She came back after her 3-year stint and needed to go out on FMLA, but had only been back for 6 months. On the surface of it, a lot of individuals would say, oh, well, Jessica hasn't been back for 12 full months. She's not eligible under FMLA, and that is incorrect. There is a break in service provision that looks at the previous 7 years in totality to determine if they were eligible. So if Jessica was eligible prior to her separating her employment in the first round of employment with ABC Company, even though she's only been back for 6 months, she's still deemed eligible under that 7-year break in service rule. So that's something to keep in mind there. The other thing that we want to look at is the reasons in which people can take FMLA leave. The very obvious, easy one is for the birth of an employee's child. Now that could be mom, dad, mom, and or dad. Okay. Another reason is for the placement of a child with the employee for adoption or foster care. We can also take job protected FMLA leave to care for a child, spouse, or parent who has a serious medical condition. And a serious medical condition is defined as undergoing care twice in a 30-day period or a 24-hour overnight in the hospital. Okay. And I'll dig more into that here in just a minute. And then lastly, we can take it when the employee is unable to perform their essential functions due to a serious health condition. Okay. So that's that. Jessica, if you're sharing your screen, yours is showing, I believe, the way that mine was showing.
Okay. Can but you can see my screen?
I can see all employers who are covered.
Okay.
So I think you were probably doing better than I was. It looks like Rebecca said that one slide was better. And it's an improvement. We'll take an improvement. How about that? Okay, I tell you what, if we can move to slide number 7, and then we should be caught up together. There we go. Perfect. Let's just also assume that we need to take FMLA for military exigency leave. An individual could take up to 26 weeks job protected leave because of the employee's immediate family member. They're being called to active duty, so we need to get the household in order. Or let's assume they've returned from active duty and they are recovering from a military related injury. So they have up to 26 weeks leave that they can take under that piece as well. I do want to look a little bit at job restoration and benefits. Now, when we talk about job protected leave, obviously there's protections written into the regulation. So a couple of things. First and foremost, when somebody requests FMLA and or we designate it, because the ultimate responsibility for determining whether or not a situation is FMLA qualifying is gonna fall back to the employer. We also have to make sure that, one, they intend to return. There has to be an intent to return after the leave in order for us to grant the leave, okay? But when they do return, they have to come back to pretty much the exact same everything. The way that the reg is written is that they have to be restored to his or her original job or an equivalent job, which is equivalent pay, benefits, and other terms and conditions of employment. Now, I've seen certain situations with the Department of Labor investigating FMLA charges of discrimination or claims of retaliation where somebody was out on FMLA, then they needed to be out a little bit longer than the 12 weeks, but we had already temporarily replaced that position, and the new person was working out great, so we brought them back into what the employer felt like was an equivalent job, but there were some differences, perhaps in the schedule, perhaps in the team that they were working with, perhaps in the slight day-to-day duties. And DOL really, really hones in on the fact that those things are not going to be considered equivalent. Even though there is the provision of equivalent, they don't really like it when we use it. So the best advice that I always provide our clients and association members with is if you're going to temporarily fill that position while they're out on leave, because we need to, we've got products or services to offer, and we need to maintain business operations, just know that it really needs to be the temp moving into a different role when that person returns versus trying to place the current employee or the initial employee in a different role. An employee's FMLA cannot be counted against the attendance policy. And also we are required to maintain all health benefits during their leave. And I'll talk more about that because a lot of times employers get in situations where people are behind on premiums, and we get a lot of calls on how to address that. But even though we have to maintain coverage, they're still responsible for their portion of the premium. If they get in arrears, there is a 31-day notice period that has to be provided to them in writing that allows them to, make payment in full within that 31 days, or else you could technically terminate their coverage. Certainly nobody wants to have to do that, but it wouldn't be the first time that I have seen that happen. Okay, so back in 2012, FMLA was updated really just to make sure that some of the language was inclusive with regard to same-sex spouses, legally married same-sex individuals. And so nothing really has dramatically changed with that update, but just know it does include same-sex legally married individuals, both for the serious health condition provision as well as the military exigency leave. It also did entitle eligible employees to take FMLA leave for stepchildren. So that was kind of a more modernized update there. A lot of times there are blended family situations where a step parent needs to be the primary caregiver of that child. So they included that as well. And they also changed the ability for an individual to care for a step parent who is the same sex spouse of the employee's parent. So that was just a little minor update there. I do want to cover some initial mistakes that I often see when we're working and supporting our clients. So mistake number one, we fail to have the proper documents. Obviously, part of the big documentation is going to be that we have to have a federal FMLA employment poster. Obviously, we know our employment posters have to be displayed in a common area. If you need one, let me know. FMLA, in terms of the poster, hasn't been updated, that particular poster, and probably like at least 10 years at this point. So you don't have to get new posters every single year unless there is an update to the federal and or state. Now, some states update them all the time. So just know that it's not one of those things where you have to constantly update your posters every single year unless there's been a change. We also have to have an FMLA policy and make sure that's announced. Typically that goes in your employee handbook. Make sure that the FMLA policy is compliantly written and that it includes all of the necessary provisions, their rights and responsibilities, those sorts of things. We also have to have appropriate requests for leave forms, medical certification forms, and templated written notices. I'll talk more about that, but I have all sorts of templated letters, the appropriate forms. If you all need them, I'm happy to share. It kind of makes life easier. There's about 6 of them, I think. And they're all saved and titled based on the particular scenario you may run into. So, whether it's a request, whether it's an approval, denial, extension, prior to leave exhaustion, perhaps they can't return, so we need to explore ADAAA. So we have all of those templates, happy to share. Mistake number 2, and I see it daily. Employees are not required to directly ask for FMLA leave. Okay, it is up to the employer to say, you've been out for an entire week or 3 days, and I think this may be FMLA qualifying. I need you to get this paperwork completed. Now, there are certain things that are very easy to anticipate FMLA leave. If somebody's going to go out for a scheduled surgery or for the birth of a baby, those sorts of things. But it's sometimes those unexpected situations where somebody has been in an accident or is in the hospital, and human resources or the person within the organization who's handling HR finds out, well after the fact that they've been out for a little bit of time. Instead of waiting for that individual to say, hey, I need some FMLA paperwork, we're required under DOL interpretation to go ahead and initiate that process. In a perfect world, the regulation states that employees must give notice, 30 days notice, unless it's impractical, so that we can get the paperwork out. We give them the 15 days to get it completed and return to us. But obviously, if the leave is unforeseeable, we just need to go ahead and determine if the situation may or may not qualify and initiate that medical certification. Mistake number 3, the supervisor. One of the things that DOL has been very, very specific on is that supervisors don't have a good understanding and or knowledge about FMLA. And certainly, we don't expect them to be experts in FMLA, but they need to know what to look for. They need to know what they can and cannot say. They need to know how to guide an individual who might be going out on leave or need leave, and kind of what the steps are there. So it's highly, highly recommended that your managers receive basic medical leave training, FMLA, ADAAA, so that they can identify potential FMLA situations and guide them appropriately. The easiest question that the supervisor or a leader within your organization can ask the employee is, how long do you plan to be out? Have you seen a doctor? Are you going to be seeing a doctor in a follow-up situation? Those are kind of the initial questions when somebody has been out for typically 3 days or longer. And then that supervisor should be communicating that back to, again, whoever the designated individual is in the organization handling this type of leave. Why aren't they able to report? We don't want to ask about specific medical diagnoses. We just want to know, have you seen a doctor? When do you plan to return? And do you have follow-up appointments scheduled? Okay. So mistake number 4 is not understanding what is considered a serious health condition. Again, it's not just for birth or surgery. It's any sort of injury, illness, impairment, physical or mental condition that would require inpatient care. So that's an overnight in the hospital, 24 hours or less, and or continuing treatment by a healthcare provider. And that's twice in a 30-day period. So common things that can qualify under FMLA, especially on an intermittent basis, is chronic health conditions, migraines, anything that would be, ongoing treatment. It's not necessarily going to be your obvious routine annual physicals, your eye exams, your dental exams. Things that we're running into right now is allergy season. Could it potentially rise to the level of FMLA? Maybe. It depends on if we're having, prescription medication, specialized treatment, addiction treatment. We just kind of rolled out a flu season. Typically, the flu is not going to qualify unless they were and they have to do follow-up visits. Mistake number 5 we see a lot is improper documentation. Like I mentioned, happy to share our forms with you and templated letters, but there is a lot of documentation that goes along with FMLA. Request for leave forms, medical examiner certificate. Once they get it in their hands, they have 15 days to get it completed and returned to us. Now, a lot of the physician offices are kind of dragging their feet on it. It takes a little bit longer. DOL says, there's a little bit of cushion in that 15-day period. So, don't kind of dig our heels in or draw the line in the sand just because they didn't quite meet the 15 days. Now, if we're talking about 2 or 3 months after the fact, then that's a different conversation. You absolutely can contact the medical provider if you need to gain additional information or clarification on certain items. If we think that there is potential FMLA abuse or that something isn't jiving in the medical certification compared to what we're hearing from the employee, you can get a second and or third opinion if necessary. Just know that we as the employer are going to have to pay for that second and third opinion. I've run into a variety of situations where we've had to do that when we expected FMLA abuse, and it can be beneficial if there's something going on there. So we have designation letters, we have exhaustion of leave letters. Everything should be sent certified mail receipt and or UPS, FedEx, where we can track it. Why? Because if we ever have to defend ourselves to the Department of Labor on a state or federal level, I need to be able to show proof of delivery. Okay. I need to show them that we did our due diligence and they failed to comply. Mistake number 5 is continued rather with the improper documentation. There's a myth that only the doctor can actually complete the certification. That's not true. We're seeing a lot of physician assistants, somebody within the medical practice that may be associated with that particular individual's case, completing the medical certification, the RN, that sort of thing. Totally fine. If we're dealing with mental health, it could be a clinical social worker. It could be another situation with a podiatrist, dentist, those sorts of things. If there's some oral surgery going on there. But if they meet the definition of a healthcare provider as defined within the Act, they can legally complete the forms. It's just not going to be like an LPN or like a front desk receptionist sort of situation. Mistake number 6, a lot of people don't realize that you can integrate or should be integrating FMLA with other leaves of absences. Okay. So any sort of paid leave available to them, short-term disability, long-term disability, it could be paid parental leave, paid adoption leave, workers' comp, ADA. All of that can run concurrently with federal FMLA. So, making sure that we are looking at both the federal piece, the state piece, if you reside in a state or operate in a state that has paid sick leave, paid family leave, those sorts of things. And the other piece that I will say is some of those states in particular have provisions where the state paid sick leave or the state paid family leave has to go before paid sick leave. So, this is where you really want to make sure that we have a firm understanding of state regulation and how that interplays with federal as well. But, we want to track all that time. We want to have good documentation associated with how much time have they taken? When are they potentially going to run out of certain paid leaves? Short-term disability typically isn't going to pay out if they have paid leave available underneath the employer internal policy. They'll start paying once all of that leave has been exhausted, depending on how the policy is written. So, we want to check all of those things too. Mistake number 7 is that the employee and the employer communications are lackluster at best. Whether that is something where we've got somebody out, they fell off our radar. We haven't stayed in touch. We haven't gotten updates on their fitness for duty or potential return to work. Perhaps they are out on intermittent leave, where they're taking, 4 hours here, 2 hours there, and there are a lot of absences adding up, and they haven't let us know, look, these are FMLA qualifying absences. And then the other thing we see is where employers have failed to notify the employee of the benefit premium responsibility. When we send the initial FMLA documentation, there should be a statement of rights and responsibilities that go along with it that outlines, look, you have to stay in touch with us. You have to let us know when you're expected to return, if that date changes, if your intent to return changes altogether. And also, by the way, you owe us these premiums by this date, et cetera, et cetera. So we want to make sure that that statement of rights and responsibilities is also included in the paperwork. Mistake number 8 is terminating right after FMLA. Back in 2012, 2013, Department of Labor changed their stance on this. It used to be previously when somebody had exhausted their 12 weeks and they were not able to return, the employer was able to say, well, best of luck, we're going to go ahead and separate employment. However, DOL now says, because they expanded ADA, is that, well, if somebody's out on FMLA leave because of a serious health condition, it likely is going to qualify underneath the Americans with Disabilities Act as amended, right? So you shouldn't be terminating employment because their job protected leave has just ended, because they're going to qualify under ADA for an additional reasonable accommodation. So we need to pause before that. That is why it's really, really important to get an updated medical certification prior to FMLA being exhausted, so that we can look and see, are they able to return? If not, when is the revised expected to return to work date? Are we looking at another month, another 2 months, another 6 months? Because all of that's really going to play into our review and our interactive process associated with reasonable accommodations. So that's just something that I see happen quite often, where people are not engaging in the ADA interactive process towards the end of FMLA, and that's something that DOL really is honing in on. Before I move into Americans with Disabilities Act, are there any questions about FMLA before we move forward? I'm going to give it a second. Feel free to use your chat feature. I can see that, so that's good. Okay. All right. Let's talk a little bit about ADA. ADA is probably the toughest job protected federal regulation to kind of navigate. We always preach consistency. What you do for one, you do for them all. But ADA doesn't necessarily always allow us to be as consistent, as very black or white with regard to policy, because everybody's medical condition and their limitations and our accommodations based on their limitations are going to be a smidge different. But really the purpose of ADA was back in the 60s was to bring in individuals with disabilities back into economic, social mainstream, and to really have a good, clear, enforceable standard for addressing discrimination against those individuals who have a disability. It really was intended to allow them to have a fair playing field and compete with other non-disabled individuals in their terms and conditions of employment. So that said, ADA has been dramatically expanded, which still leaves a lot of confusion out there for employers. So a couple of key points for us to remember. We want to kind of check our attitudes. We don't want ADA situations to really become something of a us versus them mentality. The whole requirement of the interactive process is that it's got to be joint problem solving. Does that mean we are going to, do every single accommodation that they're asking for? No, it does not. Does that mean that I absolutely have to follow the specific guidelines that the doctor has outlined in their medical certification? No, it does not. It's all a starting point. It's all a negotiation. Because what we what we rely on is that certain things may or may not create an unreasonable or an undue hardship, rather. So we want to try our best to have the same treatment and standards for everyone. Again, what you do for one, you do for them all. But sometimes there are situations, again, based on their limitations, based on their position, based on business need at that moment, where there may be modifications that differ from a modification that we had previously provided for a different employee. As with FMLA documentation, all of that medical information goes into the separate medical file. It's kept confidential. And we have to look at the job-related specifications. So that's why it's really important with your job descriptions to have your job duties as noted essential versus non-essential. Because when we get to the accommodation process, we only have to accommodate the essential functions, not the alternative or infrequent job duties that they may be doing. A few other key points to remember. Obviously, we have our legal obligations, reasonable accommodation at every step of the way. We are not going to decide and tell them, but it's going to be a joint problem solving and decision making. And that also has to be documented on what our proposals were, what the employee proposals were, what we have kind of gone back and forth on. There needs to be clear documentation there. Similarly, with FMLA, ultimately the employer is liable under Americans with Disabilities Act as well. And sometimes we have to do a case by case. Ultimate decisions for accommodations, undue hardships are always going to be determined by the facts of each case. Again, that's why our documentation, particularly with ADA, is so important, so that if it ever is challenged, that we are able to prove why it was, quote unquote, an undue hardship. So there are a variety of aspects dealing with ADA, but for purposes of our conversation today, we're going to focus on Title I, which deals with employment. Obviously, that particular definition prohibits discrimination against an individual with a disability in terms of applying, hiring, advancing, training, compensation, separation of employment, and any other terms or conditions of employment. And it also defines what a qualified individual with a disability is. So it's what ADA is saying is we don't necessarily have to hire an individual with a disability, and we don't have to not hire them. We have to look at what the KSAs are, the knowledge, skills, and abilities, and make sure that they are the most qualified individual with or without an accommodation that can perform the essential functions of the job. Okay. If they're not qualified, then they're not qualified. But again, this goes back to documentation, resumes, applications, good interview notes, focusing on the essential functions and behavioral-based questions. Okay. What is not covered under ADA? Anything that would be considered a temporary disability, broken leg. Pregnancy technically is temporary, but remember, pregnancy is protected under Title VII and pregnancy discrimination law on a federal basis. Again, state law may have additional provisions in place for pregnancy. Remember that not all permanent disabilities are going to impact major life activities. For example, a loss of a finger, unless it really is going to impact their ability to successfully perform a particular job function. Drug use may be covered under ADA, but not current use of illegal drugs, not current use of alcohol. However, if they're in recovery, that's going to be covered. Gambling, kleptomania, pyromania, not covered. As neither are sexual preferences. They are not considered disabilities underneath the Act. One thing that I hear a lot of from employers is sometimes frustration or confusion surrounding ADA. because they often feel like it's requiring them to lower performance standards. It's requiring them to have to hire somebody that they wouldn't necessarily normally hire. And none of those things are true. Okay. We're not having to report it to the government. We're not having to lower any sort of production standards. We're not having to give preferential hiring treatment. And we're most certainly not having to do unduly expensive or extremely costly modifications. Nobody's asking you to take, a building that you may have that doesn't have an elevator and put, $100,000 elevator in it. That would be considered an undue hardship. So, it's really not intended to lock you in. It's just intended to kind of level the playing field for individuals. So let's look at the basic definition of a disability. Having a physical or mental impairment that substantially limits one or more major life activity. And I'll show you what those are here in just a minute. I may also have a record of such impairment, or I've been regarded as having an impairment. Where managers often get themselves into a sticky situation is when they have regarded somebody as being impaired without having the documentation to back it up that in fact they actually do have an impairment. Okay. There are also things where we may have conditions that are episodic or in remission. And so if they are an active episodic situation, those things we have to look at would be considered under the Act. So, perfect example. In the past, mental illness, it might not have been entitled to an accommodation in the workplace when the condition was active because they did not meet the ADA definition of a disability. So, conditions in remission or who have limitations that come and go would not necessarily have been previously covered under ADA, depending on how long limitations were active. Okay. Another example here with the episodic piece is, let's just assume we have an employee with Crohn's disease and they have periodic flare-ups that would cause them to be in the hospital. Okay. Now, this is also a great example of where ADA and FMLA are playing with each other. So if it requires hospitalization and they've been employed for 12 months and 1,250 hours, boom, it's FMLA qualifying right off the bat. But we also have an ADA piece that we need to look at as well. So under the definition of a disability, we have to look at what are the limitations during the flare-up. And how do those limitations during the flare-up impact their ability to perform the essential functions of the job? Maybe it is a situation where this person requires additional bathroom breaks or additional rest breaks or time off from work because the bowel function is considered a major life activity. So it's not necessarily always just about what the condition in and of itself is. We're also looking at subsequent or secondary, what is the word that I am looking for? Secondary medical concerns, medical issues that may be tied into loosely or specifically, nausea, fatigue, other secondary symptoms that would also qualify underneath the Act that we might have to accommodate as well. Okay. So a major point for consideration, if somebody has a condition that is episodic or in remission and it limits a major life activity, we are looking at what those limitations are during a quote unquote active state, when it is flaring up, when they are having issues with it, similar to that example of the Crohn's disease. They also did in 2009 broaden the definition of regarded as impaired. So an individual is going to meet that requirement if that person established that he or she was subjected to an action prohibited underneath the Act because of an actual or perceived physical or mental impairment. Again, this is where managers sometimes get themselves into trouble. they don't know for a fact if somebody really does have a medical condition. So either they've already considered them as disabled and have unofficially accommodated, or somebody has said something, or they haven't allowed something because of a perceived physical or mental impairment. We're seeing DOL really dig in a little bit more on this regarded as being impaired. So a transitory impairment, if it's 6 months or less, it is not going to play into regarded as impaired. But again, it goes back to manager education of if somebody is asking for assistance or asking for a little bit of flexibility in something because of a quote unquote medical condition, that's when that manager needs to say, time out, talk with HR, time out, go talk to the office manager or what have you, because before we do anything, we need to actually certify that there's a medical condition here. Because once we open that Pandora's box, they're regarded as being impaired. So you take it away, what's going to happen? They're going to immediately file a charge of discrimination with the DOL or even the state DOL that you're operating in. So we want to do our due diligence. So therefore, to be covered, ADA is going to have regarded as coverage. It's very broad. It's very open, lots of room for interpretation. So we just want to be mindful of that. Here's an example of regarded as: an employer denied employment to an applicant solely because the applicant has had back problems in the past without looking at whether or not he or she could safely perform the job. That reference, and I'm going to take this a step further in the example. Let's just assume that person casually mentioned back issues in the interview. This is a reminder that we don't ask medical questions in the interview. We don't write down medical things in the interview notes. We focus on the essential functions of the job and can you perform these with or without an accommodation. So the other thing we have to look at with regard to the major life activities is whether they're going to be substantially limited. Bodily functions are included in that as well, having a major life activity limited based on the disability. So other things to keep in mind is that there are mitigating measures. We're not going to consider that. So if I have a medical condition or a disability and I'm taking medication, and as long as I'm on that medication, I'm not having flare-ups. It's not limiting my ability to function in life. We're not going to consider that medical condition. Same thing with medical supplies, equipment, low vision devices, use of assistive technology. Those things are not considered for purposes of mitigating measures. And here's a good example. Somebody that has epilepsy is taking their medication. The seizures are controlled. They're covered underneath the new definition of a disability because we are looking at her as being disabled without regarding the medication, right? So even though, yes, the medication is keeping it in line, we are still going to consider her disabled. But if the mitigating measure itself causes limitations, so if it can get tricky here. So without the medication, we know that epilepsy meets the definition. But if we are ignoring the beneficial effects of the medication itself that causes limitations, then those things may also be considered. So she might be considered double under the act that we may have to look at. So here's a list of your major life activities, obviously pretty inclusive. If there's a medical condition that impacts any of these, we need to have conversations, as well as a medical condition that is impacting a major bodily function. That was part of the expansion in 2008. And so, as I mentioned, so let's give an example of somebody that has cancer. And yes, they're covered underneath the cancer treatment, but let's assume that we're having secondary symptoms of nausea and fatigue. That's going to be tied into the immune system, and that's limiting perhaps my ability to stand and walk and interact with others. So those things would be part of the exploration and the documentation of the medical certification. Next slide is going to cover just a listing of impairments that always meet the definition of a disability. I don't think any of these are a surprise to you all, but just know there are medical conditions that are specifically defined in the Act that will always meet the definition of a disability. So what do we do, right? It's one thing to understand, so we've got ADA. What does that really mean to us? Make sure we have good job descriptions. Review them. Make sure that it is very specific what is essential, what is non-essential, what are the requirements of the position, both with education, skill set, experience, but also having that ADA piece at the back or at the bottom of the job description that talks about how much weight am I required to lift or push or pull? How often am I doing these things? Am I standing? Am I walking? Am I bending? Am I exposed to chemicals, loud noises? The environmental, chemical, sensory, and physical aspects of the job need to be clearly documented. Why? Because we need to give that to the doctor along with the medical certification so that they can look at how this medical condition really potentially might impact the requirements of the job. We always need to focus on performance and conduct. The only thing that we can manage are facts of the situation, the performance expectations, the performance standards, and manage that. ADA does not require us to modify those standards for an individual with a disability. We're just providing them assistance with accommodations to rise up and meet those standards. Again, just like with FMLA, I want our managers to be trained on ADA, what to say, what not to say, how to handle a situation if somebody's asking for a accommodation, or we have identified something's going on and we might need to accommodate. Documentation needs to be solid, and before we discipline for failure to perform or for attendance issues, or separate employment, we want to take a step back and pause and make sure that we've dotted all of our I's and crossed our T's. So the next few slides deal with the hiring process. I've talked a lot about with or without an accommodation. So when we talk about ADA and the employment procedures, a couple of things. If you are one of those employers who are dealing with pre-employment physicals, totally fine to do. Totally fine to do. As long as we are giving them to everybody for similar job categories. So let's say some of our ASA members, you're doing physicals with your field staff, but not all of your office staff. Totally fine, as long as everybody that is working in the field has been given one. We also have to make sure that it's tied back to job-related necessity. So again, if we have a physically taxing position, we want to make sure that the physical makes sense to give for that position. Obviously, they need to be consistent with business necessity, and if based on the results of that physical, we may have to provide reasonable accommodations. Okay. ADA talks about physical agility tests as not being considered medical exams. Typically, again, I'm going to tell you in terms of medical information, unless there's a conditional offer of employment on the table, we're not doing drug testing, we're not doing physicals, any of that stuff until a verbal or a written offer of employment is presented. Okay. If we do those things prior to, you were opening yourself up to significant risk of a charge under ADA. So make sure that we are doing that post job offer. Again, if somebody is not qualified to perform the essential functions, you can reject them from employment because they are not qualified. Doesn't matter whether they have a physical or mental impairment. If they don't meet the KSAs, they don't meet it. And you should always be showing them a copy of the job description during the employment process. Again, next slide just covers the way in which we can ask, can they meet the work schedule, the job duties, with or without an accommodation. If they say no, you may ask the applicant to explain further. But again, be mindful about what you write down because we don't want that to come into play or be viewed as discriminatory. Next slide gives you specific questions you may ask. Feel free to work those into your interview questions. Stating the attendance requirements. Look, we are Monday through Friday, 9 to 6, 1 hour lunch break, whatever it is. Or, look, you might be working weekends at the job site, whatever it may be. Do you have any reason to believe that you would have difficulty meeting the schedule, difficulty performing the essential job functions? Would you please explain how you would perform these? Again, that's where I really like to weave in behavioral-based questions that are focusing on how they would actually perform things, because past behavior is the best predictor of future behavior. Then once the conditional offer of employment is made, then we arrange for those pre-employment medical exams, drug tests, those sorts of things, physicals if we're doing that. If there are limitations, then again, we engage in that reasonable accommodation process. If there are no work restrictions or direct threat, then we just move on and document that piece. On your application, again, don't ask about health insurance history, workers' comp history, previous attendance records, those sorts of things. Now, depending on the state in which you are operating in, you may be able to ask workers' compensation history post-employment. So during the orientation period, there's actually a form that we have that you can have them fill out about their previous workers' comp claim history. Again, not all states permit that. A large portion of them do. So if you are large and you are self-insured, meaning that you as the employer are in charge of receiving and paying out the claims to the medical insurance providers and that sort of thing. Don't be asking about health insurance history and claims history and that sort of thing. That'll get you into trouble under ACA as well as ADA. Now, remember that substance abuse and individuals who are current users of illegal drugs are not protected underneath the Act, but those who have been in rehab and who are no longer using illegal drugs are protected, okay? So if, you end up drug testing and somebody tests positive for oxycodone or alcohol or what have you, and they have previously been to rehab, but they're using again, they're not covered underneath ADA, okay? So drug test, after conditional offer of employment, same thing with alcohol. You can still prohibit use of alcohol and illegal drugs by all employees, especially if we have safety sensitive positions. And certainly ADA does not allow anybody to be underneath the influence of alcohol or drugs at the workplace. Let's see, Jessica, I know I'm getting tight on time, so I'm going to scroll through and tell you what. Let's move up to slide 52. Reminder, medical information, anything that has a medical diagnosis needs to go in a separate confidential medical file. Supervisors, managers don't need access to that file. It needs to be under lock and key. That's a requirement under the Act, various acts, but that would include anything that is reasonable accommodation, medical certifications, workers' comp, doctor's notes with diagnoses on it, those sorts of things. Let's also see. And we're going to make sure you get a copy of this PowerPoint. In all fairness, I feel like the number of slides was a little overzealous for me today, knowing that I am a talker. Similarly with ADA and FMLA, your benefits, we can't deny benefits to somebody that, simply because they have a disability. So I do want to cover, before we start wrapping up, Jessica, let's go to slide 67, please. Let's go to slide 67, looking at reasonable accommodations. While Jessica's pulling that up, a reasonable accommodation is not going to, again, lower their performance standard. It's simply modifying or providing adjustments that enable the individual with a disability to have the same benefits and privileges of employment. So again, this is where your job description comes into play. You may also, a lot of companies will contract out, and I'm not saying you should or have to, but when there are more difficult medical situations going on, you can actually contract a workforce environment analyst, where they can look at, the job in and of itself, the current environment, how small modifications can be made to help assist this individual with a disability perform the essential functions. A lot of times the doctors will provide in their documentation, this person needs to rest or sit down or eat, or they may require, frequent breaks or time off from work, or I've had people change out light bulbs because that, reduced their triggers to migraines and seizures and that sort of thing. So a lot of times these accommodations are very easy to do. While they may not be ideal, DOL, again, is very, very focused, for lack of a better phrase, on employers who are denying reasonable accommodations and trying to utilize the undue hardship. DOL stance right now is that, look, pretty much everything can be accommodated unless it's going to cost you $25,000, and I'm just throwing out numbers here. It can be accommodated. It may not be ideal, but the burden to prove an undue hardship, they've really, really raised the bar there. Okay. So you want to make sure that you're looking at, and it is truly an interactive process between you and the individual with the disability, plus looking at the doctor certification and how we can meet in the middle and accommodate. Again, that does not lock you into saying we have to do exactly what the doctor said or what the employee is asking for. It's got to be reasonable. It's got to help us maintain performance standards, but also meet the needs of the business as well. Let me also, let's go to slide 74, please, Jessica. Thank you very much. Employer actions that may constitute discrimination: denying employment opportunities because somebody has a relationship with somebody that's disabled, and you think that may, divert their time and attention away from the employment situation. Refusing flat out to make reasonable accommodations is going to land you in some hot water with state and fed. Limiting employment or an applicant that adversely impacts opportunities for them simply because they have a disability. Using any sort of pre-employment test that we created on our own. And this actually came about from a situation back in 2007, maybe it was 2008, where one of the local fire stations up in, I want to say it was in Connecticut. And it was a big case that the DOL went against them. But anyways, long story short, the fire department did some sort of like ongoing test. It was like a competency test. They gave it to all of their, firefighters, what have you. They made this test up on their own. It was like a written test. They gave it to everybody. You either passed, you got to keep your job. If you failed, you were out. Well, what happened is they didn't provide any sort of accommodations for people that may have had ADD, ADHD, and any other, intellectual disabilities that would require them to have additional time or an interpreter or whatever it may have been. In addition, I want to say that because the test was not statistically valid and reliable, it inadvertently targeted or called out individuals with minority status as well. So long story short, they got sued. Don't make up your own pre-employment or competency test. Use a test that has been validated, it's significant, those sorts of things, so that we're not running into hot water with ADA there. Let's go to slide number 76. So practical tips for compliance. Review your job descriptions, check your standards, make sure that we have good accommodation procedures in place. Just like you will with FMLA, you have to have an ADA policy in your handbook, which informs the individuals on how to request accommodations and kind of our steps and how we will handle that. Number 2, always focus on performance and conduct. Don't make assumptions. Don't lead employees to believe decisions are made based on their disability, real or perceived. Focus on the facts, observable behaviors, and more importantly, in performance conversations, the conversation of the disability, their limitations should never be brought up. Never, never, never. Okay. Make sure we have good documentation. Just like with FMLA, the accommodation process should be documented, certified letters, everything goes mailed receipt, especially if we're doing an extended leave of absence on the back end of FMLA. General rule of thumb is 60 days is pretty much court standard. 30 days is fine, but I always try to encourage you 45 to 60 days is a little bit nicer. They're still also going to have a return to work piece as well. You certainly want to make sure to train your managers on, more importantly, refraining from discussing medical conditions unless they're absolutely relevant. Making sure that they understand how they can reduce retaliation claims based on, not engaging in negative or derogatory comments. Documentation being solid, making sure we have good paperwork on actions and decisions and medical certifications there. So I know I threw a lot at you in a very short amount of time. Do I have questions? Do I have anything that I can address for you all at this point? Oh, look at all these questions that came in. I didn't even see that. Okay. Jessica, I'm just going to go ahead and read these if you're fine with that.
Okay, that works.
I try to be self-sufficient. If you are a union contractor, the employer is responsible for healthcare contributions during the leave for the union. Yeah, that's going to be based on potentially your collective bargaining agreement. If that was part of the agreement, you may be required for that. But let's just talk generally speaking. Let's say that the CBA has not covered whether you have to pay it or not. Remember that your carrier contract is also going to dictate your employer responsibility for their premium. I've never seen anything written into a health insurance contract where the employer was not responsible for no less than 50% of the employee only portion. So yes, you're going to want to maintain your employer portion. What happens is we typically pay the entire premium up front anyways the month before, and then we recoup the employee portion via payroll deduction. So keep that up, because what we don't want to do is violate the carrier contract either. Now, there are situations where FMLA has exhausted, somebody's out on ADA. That benefit contract typically is also going to outline, and let's just use Blue Cross Blue Shield, for example. That Blue Cross Blue Shield contract is going to say, look, when somebody's out on a period of disability or medical leave, they can remain active on the plan up to 120 days, up to 6 months, after which we need to issue COBRA. So again, this is a good reminder to review your contracts, review your collective bargaining agreement, and make sure that we fully understand what our responsibilities are as the employer. So Kelly, thank you for that question/comment. Petra, can an employee be forced to use PTO before going out on FMLA? Ooh, good question. Here's what I'm going to tell you. I want you to run PTO concurrently with FMLA. Why? Because if you force them to use PTO up front and then enact FMLA, they're going to be out 14, 16 weeks. Your policy should include how you're going to handle paid leave with regard to FMLA. I strongly, strongly encourage you to run it concurrently together. Certainly you don't have to, but it's our recommendation. Let's see. I think that's all the questions that we have. If there are any questions, any additional questions, feel free to use the chat feature there. But again, reminder, you have unlimited telephone and email access to SESCO. So if you have follow-up questions, feel free to reach out. If you need any sort of templated forms, also feel free to reach out. I believe Jessica will be sending a copy of the PowerPoint out to you all as well. So
correct. So with that, we will go ahead and conclude. Thank you, Jamie, for your presentation. Thank you, everyone, for joining us today. And as Jamie said, we will get these slides to you, and the recording of the presentation will be available at the end of the day today. So with that, thank you, everyone. Again, thank you, Jamie, and we look forward to you joining us on our next webinar.
yes, thank you, everybody. Have a great day.
You too. Bye-bye.